to date. Without objection, so ordered. The Sergeant-at-Arms will make the proclamation.
Hear ye, hear ye, hear ye. All persons are commanded to keep silent on pain of imprisonment while the Senate of the United States is sitting for the trial of the articles of impeachment exhibited by the House of Representatives against Donald John Trump, President of the United States.
Mr. Chief Justice.
The Majority Leader is recognized.
As the chaplain has indicated, on behalf of all of us, a happy birthday. I'm sure this is exactly how you had planned to celebrate the day.
Well, thank you very much for those kind wishes, and thank you to all the senators for not asking for the yays and nays.
And for the information of all senators, we should expect a break every 2 or 3 hours, and then at 6 o'clock, a break for dinner. And with that, Mr. Chief Justice, I yield the floor.
Pursuant to the provisions of Senate Resolution 483, the Counsel for the President have 22 hours and 5 minutes remaining to make the presentation of their case. The Senate will now hear you. Mr. Sekulow.
Thank you, Mr. Chief Justice, members of the Senate, managers. What we've done on Saturday is the pattern that we're going to continue today as far as how we're going to deal with the case. We deal with transcript evidence. We deal with publicly available information. We do not deal with speculation, allegations that are not based on evidentiary standards at all. We are going to highlight some of those very facts we talked about very quickly on Saturday. You're going to hear more about that. I want to give you a little bit of an overview of what we plan to do today in our presentation. You will hear from a number of lawyers. Each one of these lawyers will be addressing a particular aspect of the President's case. I will introduce the issues that they're going to discuss, and then that individual lawyer will come up and make their presentation. We want to do this on an expeditious but yet thorough basis. Let me start with, just for a very brief few moments, to take a look at where we were. One of the things that became very clear to us as we looked at the presentation from the House managers was the lack of focus on that July 25th transcript. And that's because the transcript actually doesn't say what they would like it to say. Now, we've heard, and you will hear more about that in the days ahead. We know about Mr. Schiff's version of the transcript. You heard it, you saw it. I want to keep coming back to facts. Facts that are really undisputed. The President, in his conversation, was clear on a number of points, but so was President Zelensky. I mentioned that at the close of my arguments earlier, that it was President Zelensky that said, no pressure. I didn't feel any pressure. And again, as this kind of reading of minds of what people were saying, I think we need to look at what they actually said and how it's backed up. It is our position as the President's counsel that the President was at all time acting under his constitutional authority, under his legal authority, in our national interest, and pursuant to his oath of office. Asking a foreign leader to get to the bottom of issues of corruption is not a violation of an oath. It was interesting because there was a lot of discussion the other day about Lieutenant Colonel Vindman, and one of the things that we reiterate is that he himself said he did not know if there was anything of crime or anything of that nature. He had deep policy concerns, and I think that is what this is really about, is deep policy concerns, deep policy differences. But we live in a constitutional republic where you have deep policy concerns and deep differences. That should not be the basis of an impeachment. If the bar of impeachment has now reached that level, then for the sake of the republic, the danger that puts not just this body, but our entire constitutional framework in, is unmanageable. Are we going to have every time there's a policy difference of significance or an approach difference of significance about a policy, we're going to start an impeachment proceeding? But, you know, as I said earlier, I don't really think this was about just a phone call. There was a pattern in practice of attempts over a 3-year period to not only interfere with the president's capability to govern, which, by the way, they were completely unsuccessful at. Just look at the state of where we are as a country. But also interfere with our constitutional framework. I'm going to say this, because I want to be brief. We are going to have a series of lawyers address you. So it will not be one lawyer for hours and hours. We're going to have a series of lawyers address you on a variety of issues. This is how we envision the president's defense going. We thought it would be appropriate to start with an overview, if you will, of some of the significant historical issues and constitutional issues involving impeachment proceedings, since we don't have a long history of that, and I think that's good for the country that we don't. And I think we would all agree. But if this becomes the new standard, the future is going to look a lot different. So we're going to hear next from my co-counsel, Judge Kenneth Starr. Judge Starr is a former judge for the U.S. Court of Appeals for the District of Columbia. He served as the 39th Solicitor General of the United States, arguing cases before the Supreme Court of the United States on behalf of the United States. I had the privilege of arguing a case alongside Judge Starr. We were talking about it earlier, many years ago. He also served as the independent counsel during the Clinton presidency and authored the Starr Report. He testified for almost 12 hours before the Judiciary Committee with regard to that report. Judge Starr is very familiar with this process. He is going to address a series of deficiencies. There's legal issues with regard to Articles 1 and 2, constitutional implications, historical implications, and legal implications of where this case now stands. So I would like to yield my time right now to, if it would please, Chief Justice Kenneth Starr.
Mr. Starr?
Thank you, Mr. Chief Justice, House managers, and staff, members of the Senate, the Majority Leader, and the Minority Leader. At the beginning of these proceedings on January 16, the Chief Justice administered the oath of office to the members of this body, and then again on Tuesday. In doing so, the Chief Justice was honoring the words of our Constitution, Article 1, Section 3. We all know the first sentence of that article by heart. The Senate shall have the sole power to try all impeachments. But then the constitutional text goes on to say this: when sitting for that purpose, they shall be on earth oath or affirmation. That oath or affirmation in turn requires each member of the Senate to do impartial justice. Now, this constitutionally administered oath or affirmation has been given in every proceeding in this body since 1798. Indeed, to signify the importance of the occasion, the Senate's more recent traditions call for you, as you did, to sign the book. And that book is not simply part of the record, it's entrusted to the National Archives. In contrast, members of the House of Representatives do not take an oath in connection with impeachment. The framers of our Constitution well knew when an oath or affirmation should be required. The Senate, yes. The House, no. And thus, each member of the world's greatest deliberative body now has special, indeed unique, duties and obligations. Duties imposed under our founding document. During the Clinton impeachment trial 21 years ago in this chamber, the Chief Justice of the United States ruled in response to an objection that was interposed by Senator Tom Harkin of Iowa. The senators are not sitting as jurors, Senator Harkin noted. And the Chief Justice agreed with that proposition. Rather, the Senate is a court. In fact, history teaches us that for literally decades, this body was referred to in this context as the High Court of Impeachment. So we're not in a legislative chamber during these proceedings. We're in a tribunal. We're in court. In Federalist 78, Alexander Hamilton, who's been quoted frequently in these proceedings, but in Federalist 78, he was describing the role of courts, your role. And in doing so, he distinguished between what he called the exercise of judgment, on the one hand, which is what courts do, and the exercise of will or policy preferences, if you will. On the other hand, that's what legislative bodies do. According to Hamilton, courts were to be, in his word, impartial. There's that word again. And you know, that's a daunting task for judges struggling to do the right thing, to be impartial, equal justice under law. It's certainly hard in life to be impartial. In politics, it's not even asked of one to be impartial. But that's the task that the Constitution chose to impose upon each of you. And significantly, in this particular juncture in America's history, the Senate is being called to sit as the High Court of Impeachment all too frequently. Indeed, we are living in what I think can aptly be described as the age of impeachment. In the House, resolution after resolution, month after month, has called for the president's impeachment. How did we get here? With presidential impeachment invoked frequently in its inherently destabilizing as well as acrimonious way. Briefly told, the story begins 42 years ago. In the wake of the long national nightmare of Watergate, Congress and President Jimmy Carter collaboratively ushered in a new chapter in America's constitutional history. Together, in full agreement, they enacted the independent counsel provisions of the Ethics in Government Act of 1978. But the new chapter was not simply the age of independent counsels. It became, unbeknownst to the American people, the age of impeachment. During my service in the Reagan administration as counselor and chief of staff to Attorney General William French Smith, the Justice Department took the position that, however well-intentioned, the independent counsel provisions were unconstitutional. Why? In the view of the department, those provisions intruded into the rightful domain and prerogative of the executive branch, of the presidency. The Justice Department's position was eventually rejected by the Supreme Court, but most importantly, in helping us understand this new era in our country's history, Justice Antonin Scalia was in deep dissent. Among his stinging criticisms of that law, Justice Scalia wrote this: "The context of this statute is acrid with the smell of threatened impeachment." Impeachment. Justice Scalia echoed the criticism of the court in which I was serving at the time, the District of Columbia Circuit, which had actually struck down the law as unconstitutional, and a very impressive opinion by renowned Judge Lawrence Silberman. Why? Why would Justice Scalia refer to impeachment? This was a reform measure. There would be no more Saturday night massacres, the firing of special prosecutor, as he was called, Archibald Cox, by President Nixon. Government would now be better, more honest, greater accountability, and the independent counsel would be protected. But the word impeachment haunts that dissenting opinion, and it's not hard to discover why. Because the statute, by its terms, expressly directed the independent counsel to become, in effect, an agent of the House of Representatives. And to what end? To report to the House of Representatives when a very low threshold of information was received that an impeachable offense left undefined may have been committed. To paraphrase President Clinton's very able counsel at the time, Bernie Nussbaum, this statute is a dagger aimed at the heart of the presidency. President Clinton nonetheless signed the reauthorized measure into law, and the nation then went through the long process known as Whitewater, resulting in the findings by the office which I led, the Office of Independent Counsel, and a written report to the House of Representatives. That referral to Congress was stipulated in the Ethics in Government Act of 1978. To put it mildly, Democrats were very upset about what had happened. They then joined Republicans across the aisle, who for their part had been outraged by an earlier independent counsel investigation, that of a very distinguished former judge, Lawrence Walsh. During the Reagan administration, Judge Walsh's investigation of what became known to the country as Iran-Contra spawned enormous criticism on the Republican side of the aisle, both as to the investigation itself, but also as to the statute. The acrimony surrounding Iran-Contra, and then the impeachment and the trial, and President Clinton's acquittal by this body led inexorably to the end of the independent counsel era. Enough was enough. And living through that wildly controversial 21-year bold experiment with the independent counsel statute, Congress, in a bipartisan way, had a change of heart. It allowed the law to expire in accordance with its terms in 1999. That would-be and well-intentioned reform measure died a quiet and uneventful death, and it was promptly replaced by Justice Department internal regulations promulgated by Attorney General Janet Reno during the waning months of the Clinton administration. One can review those regulations and see no reference to impeachment. None. No longer were the poison pill provisions of presidential impeachment part of America's legal landscape. They were gone. The Reno regulations seemed to signal a return to traditional norms. Impeachment would no longer be embedded in the actual laws of the land, but returned to the language of the Constitution. But in the meantime, America's constitutional DNA and its political culture had changed. Even with the dawn of the new century, the 21st century, impeachment remained on the lips of countless Americans and echoed frequently in the people's house. The impeachment habit proved to be hard to kick. Ironically, while this was happening here at home, across the Atlantic, the use of impeachment as a weapon disappeared. In the United Kingdom, from which, of course, we inherited the process, impeachment was first used more than 2 centuries before those first settlers crossed the Atlantic. But upon thoughtful examination, a number of modern-day parliamentary committees looked and found impeachment to be obsolete. Among other criticisms, members of Parliament came to the view that the practice, which had last been attempted in Britain in 1868, fails to meet modern procedural standards of fairness. Fairness. As Sir William Mackay recently remarked, impeachment in Britain is dead. Yet here at home, in the world's longest-standing constitutional republic, instead of a once-in-a-century phenomenon, which it had been, presidential impeachment has become a weapon to be wielded against one's political opponent. In her thoughtful Wall Street Journal op-ed a week ago Saturday, Peggy Noonan wrote this: "Impeachment has now been normalized. It won't be a once-in-a-generation act, but an every administration act. Democrats will regret it when Republicans are handing out the pens of the signing ceremony." When we look back down the corridors of time, we see that for almost our first century as a constitutional republic, the sword of presidential impeachment remained sheathed. Had there been controversial presidents? Oh, yes, indeed. Think of John Adams and the Alien and Sedition Acts. Think of Andrew Jackson and Henry Clay. Were partisan passions occasionally inflamed during that first century? Of course. Unless there be any doubt, the early Congresses full well knew how to summon impeachment to the fore, including against a member of this body, Senator William Blount of Tennessee. During the Jefferson administration, the unsuccessful impeachment of Justice Samuel Chase, a surly and partial jurist who was nonetheless acquitted by this chamber, became an early landmark in maintaining the treasured independence of our federal judiciary. It took the national convulsion of the Civil War, the assassination of Mr. Lincoln, and the counter-Reconstruction measures aggressively pursued by Mr. Lincoln's successor, Andrew Johnson, to bring about the nation's very first presidential impeachment. Famously, of course, your predecessors in this high court of impeachment acquitted the unpopular and controversial Johnson, but only by virtue of senators from the party of Lincoln breaking ranks. It was over a century later that the nation returned to the tumultuous world of presidential impeachment, necessitated by the rank criminality of the Nixon administration. In light of the rapidly unfolding facts, including uncovered by the Senate Select Committee, and an overwhelmingly bipartisan vote of 410 to 4, the House of Representatives authorized an impeachment inquiry. And in 1974, the House Judiciary Committee, after lengthy hearings, voted again in a bipartisan manner to impeach the President of the United States. Importantly, President Nixon's own party was slowly but inexorably moving toward favoring the removal of their chosen leader from the nation's highest office, who had just won re-election by a landslide. It bears emphasis before this high court. This was the first presidential impeachment in over 100 years. It also bears emphasis. It was powerfully bipartisan. And it wasn't just the vote to authorize the impeachment inquiry. Indeed, the House Judiciary Chair, Peter Rodino of New Jersey, was insistent that to be accepted by the American people, the process had to be bipartisan. Like war, impeachment is hell, or at least presidential impeachment is hell. Those of us who lived through the Clinton impeachment, including members of this body, full well understand that a presidential impeachment is tantamount to domestic war, albeit thankfully protected by our beloved First Amendment, a war of words and a war of ideas. But it's filled with acrimony and it divides the country like nothing else. Those of us who lived through the Clinton impeachment understand that in a deep and personal way. Now, in contrast, wisely and judiciously conducted, unlike the United Kingdom, impeachment remains a vital and appropriate tool in our country to serve as a check with respect to the federal judiciary. After all, in the Constitution's brilliant structural design, federal judges know, as this body full well knows from its daily work, a pivotally important feature: independence from politics, exactly what Alexander Hamilton was talking about in Federalist 78. During the Constitution's term, good behavior, in practical effect, life tenure. Impeachment is thus a very important protection for we, the people, against what could be serious Article III wrongdoing within that branch. And so it is that when you count, of the 63 impeachment inquiries authorized by the House of Representatives over our history, only 8 have actually been convicted in this high court and removed from office. And each and every one has been a federal judge. This history leads me to reflect on the nature of your weighty responsibilities here in this high court as judges in the context of presidential impeachment. The 4th presidential impeachment, I'm counting the Nixon proceedings, and our nation's history, but the 3rd over the past half-century. And I respectfully submit that the Senate, in its wisdom, would do well in its deliberations to guide the nation in this world's greatest deliberative body to return to our country's traditions when presidential impeachment was truly a measure of last resort. Members of this body can help, and in this very proceeding, restore our constitutional and historical traditions. Above all, by returning to the text of the Constitution itself. It can do so by its example here in these proceedings, in weaving the tapestry of what can rightly be called the common law of presidential impeachment. That's what courts do.